Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Oftentimes, orders of the court, while final, are subject to modification. This is particularly true when we're dealing with children. The court issues orders. The orders have to do, let's say, with custody, parenting time, support, something that has to do with the child. It doesn't mean, though, that that's always the way it's going to be. Really, when the court issues those orders, for all intents and purposes, what the court is truly saying is, this is my order until I change my mind and modify it. This is the order until further order of the court. Because anything about a child can always be re-evaluated for the purpose of determining, are we servicing the best interest of the child? And if we did service the best interest of the child in 2021, does that continue to be in service of those best interests? Sometimes not. Now, people will wonder, I don't like the custody. When can I modify it? Well, I will tell you one thing. When the court looks to modifying custody, the main thing, and really the first thing the court looks into, is there some change in circumstances? The court is going to want to find a significant change in circumstances before it even considers whether or not the issue should be revisited. So it's not enough to say, well, you've had the kid for 2 years, it's my turn. Well, that's not what the order says. That's not how the court, and such an order wouldn't even be appropriate, because a court can't say, okay, you have the child till 2026, so you have the child from 26 to 28. It doesn't work that way. The statute requires the court to make an evaluation of what's in the best interest of the child. If the best interest of the child were to continue where the child was last year, then it wouldn't be appropriate for an automatic triggering mechanism to move the child. So the court always has to take that into account. When should you ask for a modification? Well, you're going to have a significant change in circumstance before the court even considers that. I have people who call, the ink is still wet on the order and they already want to modify it. The court has gone through great pains to take into account, after no doubt contested hearings, about what's in the best interest of the child, and finally evaluated all the factors and came up with a decision. Do not expect that the court is willy-nilly going to just change its mind immediately. The court is going to have to be satisfied that the best interests of the child are no longer being served. In order to do that, the court's going to have to feel that it was right when it made its decision, but the circumstances have changed, so that decision is no longer the right thing to do. That's not going to happen in a week. It's not likely that in a month the court is going to see a big change in circumstances. Could it happen? Yes. The court might change it because, for example, they give custody to someone and they drop dead. The court gives custody to someone and 3 weeks later are jailed for a felony cocaine possession. The court could theoretically find a dramatic change in circumstances early, but in most cases, with the average movement of life, it's not likely to happen. And just because the child is getting older and the child might want to leave, that's not going to cut it. The court's order presupposes that the children will in fact continue to age, as we all are. So the court's going to have to see a change in circumstances, and my experience is that changes in circumstances of that nature usually don't occur so quickly. It usually is a slow evaluation, a slow evolution of what goes on over time. So when the court does make an evaluation, it's going to be a slow evaluation. It's going to be a deliberate evaluation, not based on some quick maneuver, but based on what has happened over the last year or two. Is there a change that, had we known about it before, we would have done it the other way? Is there something that's significant that should cause us to revisit this issue? That's really what the court is looking at. And when you've got that, when you've got the significant change in circumstances, that's the appropriate time to ask for a modification in custody. If you have any questions about your case, reach out. Of course, we'll be glad to help you out.